Good day, everyone. My name is Dan Sampaio, and I'm delighted to welcome you to today's Mondaq webinar in association with Gönenç Gürkaynak Attorneys at Law. I am thrilled to be joined by the excellent Mr. Gönenç Gürkaynak today. Gönenç Gürkaynak is a founding partner of Gönenç Gürkaynak Attorneys at Law, a leading law firm of 90 lawyers based in Istanbul, Turkey. He holds an LLM degree from Harvard Law School and is qualified to practice in Istanbul, New York, England and Wales, and Brussels. Today, Mr. Gürkaynak will be focusing on the essential elements of an effective competition law compliance program. Now, before we get started, here is how you can get involved in today's event. You have the opportunity to submit questions by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we'll address as many as possible during our Q&A session at the end of today's presentation. I would now like to hand you over to Gönenç to begin today's webinar. Thank you.
Thank you, Dan. Appreciate it. We're going to take a look into competition law compliance programs and trainings, particularly from the client experiences perspective, and we will try to have some observations that might be helpful to colleagues and the participants for the future as well. When we talk about competition law compliance programs, we're talking about the preventative side of competition law work. So this is where we try to avoid the existence of a violation. We try to make sure that all acts of the company are compliant. Next slide, please. So the first thing that comes to mind about these matters is that one cannot have separate silos of compliance, and at least one cannot expect a particular synergy in the compliance sphere in an entity if there isn't a holistic approach to compliance. The establishment of a compliance program necessarily goes after irregularities, and irregularities, when they come about, they happen in different fields of practice in the same company. So it is very efficient and necessary that there is a holistic approach to compliance, which allows for the employees and business people to develop their own compass about what is right and what is wrong in fields like competition law and anti-corruption and compliance with company policies in general. Typically, when you see that certain policies are taken lightly and are being violated at a company, there is a higher likelihood that certain other policies can also be violated. So a holistic approach to compliance is therefore the way to go. Legal concerns also may feed each other as well, both culturally. So the legal concerns brought about by violating acts might trigger each other, but also the existence of one type of violation might increase, as I said, the propensity to the other. This means that while you're doing internal investigations, while you are coming up with compliance programs, you will always have an eye for irregularity in a broader sense than only competition law. Of course, different approaches to compliance are inevitable because ultimately there are different spheres of law that are impacted, but the main matter comes down to ends not justifying the means, and the fact that someone has ordered you to do something, or the fact that your superior was copied on the same correspondence, or the fact that you were under a lot of pressure to hit some targets that are imposed by corporate, will not save you from the internal investigation, which means that you better listen carefully during this education seminar, this training seminar. Otherwise, there will be trouble. This particular type of approach means that the employee should be hearing compliance concerns of the company in a holistic manner. Next slide, please. Now, this holistic approach to compliance also means that there needs to be an understanding about the interplay between competition law, anti-bribery, data protection, and in general, these should be seen as a part of the whole, or as parts of the whole. From a practical point of view, anti-competitive practices and corruption have similar types of dynamics. And they also lead to a societal loss that is not too dissimilar either. When the company is fighting anti-corruption on one hand, obviously it's going after its ethical duty to do so, but also the company is making sure that what they are establishing with a teaspoon at the antitrust sphere is not being taken away with a soup spoon in the anti-corruption side, because as you know, antitrust is targeting welfare maximization, and the same can be said at some level for anti-corruption goals as well. If we are looking at a corrupt marketplace, then there will be no meritorious competition, and the name of the game is not going to be to sell the highest quality of product or service with the least possible amount of pricing. Overall, the employees that are subjected to different trainings find anti-corruption trainings easier to follow and understand, and that's understandable, because basically it does come down to thou shalt not steal at some point, and their overall moral compass works better in the anti-corruption field. Maybe in the antitrust field for cartels, the same type of slam dunk prima facie view on what is right and what is wrong is available, but the minute you start getting into, say, loyalty inducing rebate schemes and what have you, more complex types of competition law violation, understandably, the owners of entities, the business people, stakeholders, they start getting puzzled. So there is more of a lecture, a function of professing to be provided in that particular type of education seminar. Next slide, please. One thing that is quite important, and we had promised that we're going to keep this focused on the needs of the entities, and we're going to keep it focused on real life experiences. One thing that comes to mind is to take care of the tone in the middle, and to not only be content with the tone at the top. This is the point on penetration of compliance in general. The approach towards senior management and the approach towards middle management should not differ when it comes to compliance matters, and competition law compliance cannot be secured without the tone at the top, but the tone at the top is not sufficient. So without it, we cannot penetrate. So the higher management, the CEO level, the COO level, and overall the business people and professional managers that are close to stakeholders have to adopt the correct tone, that this, i.e. compliance, is the priority of the company, and all else starts after compliance is secured. But in the same vein, it would be necessary to understand that this should be penetrated into the middle ranks, because the middle ranks are the ranks that are engaging in field activities, and they are the ones that are in trenches. if the tone at the top were to not trickle down to the middle ranks, the middle ranks can alienate themselves and isolate themselves and believe that ultimately the tone at the top is all a charade. They are speaking that language because they have to, but I'm in the hot warfare zone of things, and things are done a little differently over here. So it's kind of like a you can't handle the truth kind of an approach, if I'm allowed to use a few good men movie analogy. To fight with it, one would need to make sure that some trainings are delivered face to face, that not all compliance trainings are are being done digitally, and the senior management should have visibility in terms of the day-to-day actions of the company in general. So there has to be some interference with the middle management to understand what is being handled how. The middle management might be more prone to be steered by individual commercial incentives with their annual targets and the promotion goals and what have you. And this is not something to be belittled. These people ultimately are working and they want to get their reward, and targets are being placed. So the tone at the top cannot only be a preaching kind of an attitude. It will have to actually make sure that practicable advice is being provided, and what is being asked of the middle management is also that they comply. They comply, and with that compliance in mind, their targets and their promotions are being considered. In general, one would need to say that if you lose the tone in the middle, you're going to lose this battle, because the tone at the top, it may be impeccable, but the people in the middle ranks are the people who are actually constituting the backbone of the entity in terms of compliance. So one has to penetrate there. Obviously, if you were to gain the trust of the middle ranks, but if you were to not get the sufficient traction from the top, so you lose the tone at the top, that's a non-starter as well, and the penetration cannot happen. So you need both. Next slide, please. Another important matter is maintaining the correct mindset, and always remembering that this is a mindset matter ultimately. So trainings shouldn't only convey principles. Here are the principles. Here is what the policy book says. This is not a sufficient training. The mental preparation of the employees should be done. Employees must embrace the importance of compliance in the face of pressure, understanding that they're going to be tested while writing an email message, while thinking of sending a WhatsApp message, while interacting with a counterpart to try to solve a specific problem. So they will always have to have that at the back of my mind. I am always churning the compliance ideas, and I'm making sure that there is no foul in terms of compliance. So the idea of coming up with certain keywords, for example, that should not be used in email correspondences, or installing programs that are going to catch certain keywords that are being used in email correspondences. These cannot belong to the compliance world in a sustainable manner, because these don't teach the merits of compliance to the employees, and the employees only learn how to circumvent detection. Whereas what needs to be taught to the employees is that this is a matter of correct mindset, and compliance on the merits is what is being requested. Of course, the cosmetics of the matter is also important, because you don't want to be carried into a full-blown investigation after every down raid, and the way to secure that that's not happening is that at first sight, the company comes across as a compliant company, and that has to do with the cosmetics as well. But you are not in the business of handling cosmetics ultimately. And while the cosmetics of the matter is not not important, it is quite essential to understand that the company employees engaging in correspondences on behalf of the company should see matters from a substantive perspective rather than a cosmetics perspective. So it cannot be a matter of, ooh, let me work my language around a clearer language so that I fudge the issue, but my aims are the same. If your aims are lawful, there will be no problems. If your aims, your objectives are unlawful or are violating the company policies, then regardless of how well you have worded your messages and how much you have fudged the underlying goal, there is a compliance problem there. And these need to be transparently communicated to the employees in the form of follow the rules kind of simplicity. Next slide, please. So how then to tailor and promote a genuine antitrust compliance program? Well, a genuine antitrust compliance program's starting point might be the general guidance of well-established and sophisticated antitrust authorities. There are guidance papers and manuals by the European Union, the Department of Justice, or national competition authorities, such as the Turkish Competition Authority for that matter. And the intersecting / overlapping principles are a good way to start. Of course, you cannot have a one-size-fits-all kind of an approach. Ultimately, you need a set of rules that are designed for that particular industry. And that needs to also take into account how business is being handled in that industry and what competition law risks are paramount in that particular industry, so that you put the emphasis on the correct matters and you underline the correct issues and you focus on matters that are actually plausible, possible, palatable in the particular industry at hand. Of course, there will have to be internal inspections and periodical trainings. If you don't have any internal inspections of compliance, then the compliance program may become very quickly, unfortunately, a matter that is left to the bookshelves. So they have printed the compliance program and they have velo bound it and they have placed it in their shelves, but no one really remembers it in a day-to-day kind of fashion. So a good training would highlight issues with use of language. A good training would highlight specific examples found through internal inspections done at the entity. Of course, setting up an internal whistleblower mechanism is also quite useful. When an internal whistleblower mechanism is found at the client company, at least there can be instances of people not being isolated for witnessing a violation. They can go and report to the hotline. The whistleblower mechanism would give depth to the compliance program. The downside of it might be that employees might hijack the whistleblower mechanism to some extent, and they may use it for their own career advancement goals, or there may be bogus whistleblower approaches into the hotline. These are things that we see in practice as well, but just because that might happen or that occasionally does happen, the company cannot afford to close down the whistleblower mechanism entirely and do away with the hotline, because the hotline is basically what allows the company to say that the company has actually given a red flag to each and every single employee, and the employee had the chance to waive that red flag if they were to be facing irregularities. Otherwise, it is very difficult to claim in trainings, in compliance trainings, that the employees should raise their voice. The employees should not turn a blind eye, because the employee would then say, well, my reporting line is what I am interacting with day to day, and I don't know how deep this irregularity goes. So how was I going to secure myself in reporting the problem to the company? I didn't even know how to reach the correct individuals who are going to investigate the matter. It is not infrequent that sometimes even the allegations would implicate the HR department or the in-house legal team. And in those instances, a correctly devised hotline may go a long way in making the company aware of issues and problems. In any case, the appointment of an antitrust compliance officer and the utilization of disciplinary mechanisms and incentives in the same mechanism would be quite necessary. Next slide, please. So as indicated, periodical trainings and monitoring would be essential in the sense that the compliance rules and handbooks of the company would need to be a living organism. And as business practices change, these need to be taken into account. For example, in the last couple of years especially, a lot of professional correspondences have been carried to WhatsApp. And in the recent years, we have seen quite significantly the antitrust authorities, including the Turkish Competition Authority, looking into WhatsApp correspondences. We also have seen that sometimes employees feel that WhatsApp is primarily a personal space anyway. So if their mobile phones are requested by the Turkish Competition Authority, they may try to uninstall WhatsApp and then deliver their device. Now, in a compliance training, you will have to explain that if that WhatsApp channel has been used in the past for any professional reason, then they do not have the right to uninstall when this is requested by the Turkish Competition Authority in circumstances of a downgrade. This sentence would not be available in a compliance training just 5 years ago. But now we come up with this sentence because we know how the practice is evolving. Much like that, the business practices, the loyalty-inducing mechanisms of the company, the exclusivity igniting mechanisms of the company, and other practices of the company might change over time. And to the extent you're taking on the compliance duties of a dominant company, then you would have to deliver speeches and your training seminar accordingly. Next slide, please. Of course, an extremely important point on that is the scope and depth of internal investigations. Let's assume for a minute that there has been an issue and you would like to conduct an internal investigation to see whether it is true that there is the alleged issue and how deep this issue goes. If you cannot determine the scope and depth of the internal investigation appropriately, you may never be able to wrap up the internal investigation. And time is of essence in these kinds of matters. Periodic inspections, internal audits that would target a wider range of employees from the business units that may entail risk from a competition law standpoint would go a long way. Because you're doing it periodically, you may be a better master of what the scope and depth of internal investigations need to be. In such a case, you are not attending a complaint, you are not attending a specific problem, and therefore you may be able to arrange the scope and depth of the internal investigation in a manner that allows you to see if there is any problem that is brewing at that given point in time. Conversely, if you are indeed looking into a competition law problem that is articulated by a complainant or by a competitor or the competition authority itself, then the scope and depth of the internal investigation may be wider and deeper, but at the same time, still, you would need to make sure that you're not entertaining all kinds of newly coming in feedback during the investigation, and that you are able to wrap up the investigation with its defined scope. This is most important when conducting interviews because, especially in certain jurisdictions, and Turkey definitely is Mediterranean in its conduct and in its culture, you would get a lot of side information during the interview. So an interview that is done in the UK or in the Netherlands or in the Nordic countries would look very different from an internal investigation that is done in Turkey, Greece, Spain, Italy. This is not profiling of people. It's a matter of how people frame their thoughts and how they convey that. Which means that while all generalizations are wrong to some extent, particularly in some countries, you may get a lot of sidetracking information, and that information might be important for other compliance reasons too, which then means that you shouldn't be stifling that incoming information, but at the same time, you need to go after your own agenda of internal investigations. This means that you need to go in with a customized question list, exploring the potential risk areas, and you shouldn't allow the interviewee to hijack the interview session, and that can only be done through well done preparation. Next slide, please. The internal whistleblower mechanism, as we said, is quite important. So first, a compliance culture would have to be promoted. The whistleblower wouldn't be demonized. The whistleblower would be someone who is law-abiding, and this preventive measure would be requested from each and every employee by the company. This would foster a compliance culture, and it would decrease the risk of potential competition law violations if it's organized efficiently. And an effective internal whistleblower mechanism would facilitate identifying non-compliance and taking necessary precautions. And the existence, by the way, of an internal whistleblower mechanism in and of itself would also be a deterrent factor. So employees in the relevant entity may feel that because of the existence of the whistleblower mechanism, they shouldn't take their chances with seeing whether they can get away with engaging in a competition law policy violation or not. Next slide, please. Of course, the existence of a competition law compliance program in and of itself is not enough. I have received a written question in the process of this presentation, and the question was whether the existence of a competition law compliance program in and of itself should be rewarded. Now, a meritorious competition law compliance program, I believe, should be rewarded, even if there has been a violation at the end of it. So in other words, competition authorities that say that your reward is the lack of competition law violation are not entirely in sync with the realities of the way markets work and how compliance can be secured. Your reward, your primary reward, obviously is avoiding violations, but in those instances where you could not avoid a violation and you are before a competition authority and you're explaining that as a company culture and from the corporate standpoint, you have taken all necessary precautions to avoid this from happening. And this is not a sham compliance program. This is in fact a meritorious compliance program. So don't I deserve you cutting me some slack, i.e. don't you recognize a mitigating factor? This is actually an opportunity for the competition authority to foster a culture of compliance programs. The competition agency could actually make sure that other entities hear about the lenient approach of the competition authority in cases where there is a substantive, well thought of competition law program in place. When we're looking at the Turkish examples, in Lindagaz in 2013, the board explicitly took the position that compliance programs are encouraged, but they could not be considered as a mitigating factor in determining the administrative monetary fine. In Frito-Lay, the board highlighted the importance of implementing a compliance program, but it indicated that implementation of a compliance program does not immunize an undertaking from violation decision in and of itself. In fuel oil, in March 2020, the fact that personnel were receiving competition law training and the existence of a competition law compliance program was not seen to demonstrate that there was no violation of competition. Now, of course, these wordings are very categoric, and they're not formulated well either at the part of the competition authority, in the sense that the Turkish competition authority, we're using it as an example, but we're looking at an emerging markets model here, and very many sophisticated competition authorities of emerged markets also use the same kind of an idea. The authorities say that you're lucky that you're not getting an aggravating factor, because since you have had a competition law compliance program, you could have even been found as knowingly engaging in these activities, as you have received a training on it and you went ahead and did this anyway. Now, that is the worst thing that you can do to compliance programs. That would kill the compliance programs, basically, and entities would start staying away from compliance programs because they can be considered as an aggravating factor. Thankfully, especially in the last decade, this approach has lost its momentum, and now it is between recognizing a mitigating factor and not recognizing a mitigating factor. Unfortunately, it is closer to not recognizing a mitigating factor at the moment, and that is very unfortunate, because another field of law, which is anti-corruption, and another sphere of compliance in the anti-corruption side, teaches us that when agencies recognize the importance of having an anti-corruption compliance program, entities actually do wonders with it. And part of the enforcement should be a compliance program as well, as in the anti-corruption field, the relevant agencies come back to the entities and say, here is your homework, this is what you need to do, here is how you can detect that there is no entanglement with corruption, and if you do all of these, then I will see that you have put forward the corporate willpower to tackle anti-corruption, or rather to tackle corruption matters. We don't see an image of this, a spillover of this kind of an approach with the competition law sphere. It's almost like agencies are insistently saying they would welcome the entity's efforts in the compliance sphere, but if I see a violation, I will act as if you haven't done anything at all. That's not how you make good public policy, in my view, and I would believe that agencies that get entangled with the details of the compliance program wouldn't be weakening themselves. They would certainly not be turning themselves into advisory bodies as to the sufficiency of compliance programs. No one is saying that they should vote on different compliance programs and they should review compliance programs as such. But when they're looking at a violation, it is only natural that competition law agencies should ask, what have you done to avoid this kind of a result? Is this result under your protection in a corporate sense, or is this a rogue employee? And these questions should be germane to the result of how much administrative monetary fine is needed to correct the will of the entity. Of course, there is a disgorgement of profits angle to the administrative monetary fine as well, and therefore we cannot suggest that there should be no administrative monetary fine if there was a spectacular compliance program, but at least some recognition of the compliance program's merits in the form of reduction in administrative monetary fine would go a very long way in encouraging entities to come up with the compliance programs. Otherwise, it seems like there's only some lip service being paid to the existence of compliance programs, but the entities are really not motivated through public enforcement to come up with sufficient compliance programs. Next slide, please. Internal and external actions in case of a potential antitrust non-compliance is also important. First of all, you would need to assess the matter from a legal standpoint, and you would need to determine the potential risk factors and their potential consequences. Then you would need to assess and determine the potential next steps. How do you manage the risk? How do you mitigate and eliminate the risk? While eliminating the risk, are you making this risk known to your competitors? Are you making your company more vulnerable? Then you will also engage in some strategic thinking about this. What is the bounds of your positive duty to eliminate the risk and to mitigate the risk? Of course, you need to stop it, that's for sure. But if you can rectify some of the consequences of it, should you be going into it? Is there a mechanism of self-reporting in the relevant jurisdiction? If there is a self-reporting mechanism, be it in the form of a leniency application or in the form of a settlement mechanism or a commitment mechanism, should this be done? And of course, the matter of doing this silently, discreetly, and swiftly. Because if you can't do it very quickly and silently, then you might be alerting your competitors to the fact that you're considering a leniency application or a commitment or a settlement mechanism approach, which may mean that they might go to the competition authority before you go to the competition authority. And as you all know, whether you're the first comer or the second comer or the third comer, and how much added value you have produced at the point in time that you have approached the authority are all germane to the analysis of what kind of a reduction in administrative monetary fine you should be afforded, or maybe a full immunity even. But if you have made a mess of the internal review, and the internal and external actions cannot be organized in such a manner that this is unknown to your competitors, or this leaks into your organization, then actually the entity might be losing quite an important momentum and also an opportunity to bring down the administrative monetary fine potentially very significantly. Next slide, please. So leniency applications are a tool of risk management option. Of course, leniency applications are not very easy because they need an acknowledgement of existence of a cartel type violation. So you cannot take a strategic view of saying, well, I'm doing the leniency application, but I actually don't believe in any wrongdoing. I'm just delivering this to you. You would have to also submit information and evidence regarding the alleged cartel. You should cease the involvement in the alleged cartel, but you cannot wake up the other members of the cartel about the existence of the cartel. And you would need to give detailed information to the antitrust authority about the duration of the cartel, the participants of the cartel, the relevant market that is impacted, and everything that you have at hand to corroborate your statements. And it's not a one-shot affair either. You would need to maintain active cooperation with the competition authority that is in question. So in a lot of the instances, if you're going to do a leniency application, this would be done in circumstances where the relevant competition agency knows nothing about the violation, and your added value creation potential is at its peak. If the authority has already downrated certain entities and has a set of evidences at hand, then it's a more convoluted analysis. And you still may have a good case to bring to the authority for a leniency application, but in most jurisdictions, you wouldn't be in the scope of a full immunity unless you are entirely changing the character of the violation that they think they have. So, for example, the authority may have raided the relevant entity with the thought that they're going to look into an RPM matter. They may have taken all the resale price maintenance documentation and evidence, and they may think that they have good evidence about this vertical violation. Even after the down raid, if you were to come forward and explain that that's actually the implementation steps of a cartel, and there is a horizontal problem going on here, and what they think is an RPM case is actually a very complex cartel case, then of course the full immunity can be discussed. But under normal circumstances, once there has been a down raid, once the authority has shown some interest in a given matter in any official capacity, the door to full immunity would close quite significantly and visibly. Of course, ultimately, there could be a non-infringement decision despite a leniency application as well. So it's not unheard of, neither in Turkey nor in other jurisdictions, it's not unheard of that although there is a leniency application by an entity that says, I think this amounts to a cartel, don't you think so? The authority might say, I didn't find the necessary evidentiary standards. This is more common in instances where there is an international cartel and the effects of that international cartel on the given jurisdiction couldn't be demonstrated. But it is also possible and has happened in the past in Turkey, certainly in the banking industry and in the healthcare equipments industry, but in other jurisdictions as well, that an entity would come forward and say, I characterize this as a cartel, and here is my leniency application, and the authority would say, with the evidence at hand, I couldn't pass the necessary standard of proof, and therefore I can't switch the burden of proof on the defendant entity, which means that despite the existence of a leniency application, I am unable to come up with an administrative monetary fine. This is well possible. Next slide, please. So in general, if we were to look into the Turkish example, the Turkish Competition Board's case law involving leniency applications would differ from case to case. In Arçelik Vestel, where this was mostly an insider job, kind of an allegation. So Arçelik was explaining to the Turkish Competition Authority that they feel someone from within has been passing on sensitive information to Vestel, and they feel that this would amount to an exchange of information among competitors, but they have never been a part of this actually. So there's another form of illegality that is happening and a violation of their company policies. The competition authority ultimately found no restrictive agreement between the relevant undertakings despite the leniency application. This is a very puzzling decision by the competition authority, I must admit, because it seems to place insider jobs outside the gambit of competition law entirely, unless they are taking the view that all of this information that flew from Arçelik to Vestel was not germane to the competitive analyses, and that it didn't have anything to do with the competitive landscape, which is not, it doesn't seem to be the position that is being taken by the Turkish Competition Authority. If you read the reasoned decision, then the mere fact that this is an individual effort of certain individuals that have done this in benefit of Vestel from Arçelik seems to have left the Turkish Competition Authority unimpressed. At least that's what one is left with as a feeling when you read the reasoned decision. In the traffic signalization matter, yet another leniency application, no documents other than the leniency application were available, and there was no sufficient evidence for an infringement finding, so no fining. In the syndicated loans matter, there was total immunity from the fine for the leniency applicant, but then a non-cartel infringement finding was in place. So this was not seen as a cartel, which is raising the hopes up for potential applications that do not amount to a cartel, but are still an antitrust violation. Maybe there might be an opening for introducing them in a leniency setting. Then in Hyundai dealers in 2013, non-cartel infringement, despite the finding of a horizontal price fixing agreement and fine reduction for the leniency applicant. So this is a bizarre decision as well. There is a horizontal price fixing agreement, which to me is a cartel, but the board says this is not a cartel infringement, but I'm giving you a fine reduction for leniency, or because this is not a cartel infringement, I'm giving you a fine reduction for your leniency application. It just feels like the authority couldn't stomach giving a total immunity, and therefore they have dressed something as a non-cartel, although all the elements of a cartel seems to be in place. In mechanical engineering in December 2017, there was a total immunity from the fine for the leniency applicant, where the Turkish Competition Board fined 14 of the freelance mechanical engineers were engaged in a profit-sharing cartel. And one entity has gotten total immunity. So this is a textbook example of a successful leniency application. Next slide, please. There is a commitment mechanism as a potential solution, and this is recently introduced in the Turkish competition legislation. So during the preliminary investigation especially, but also in the full-fledged investigation stage, the entity can approach the Turkish Competition Authority and provide a set of commitments which would allow it to be removed from the scope of the investigation if accepted by the Turkish Competition Authority, and this can be done without prejudice. Of course, if you're looking at hardcore restrictions such as price fixing, territory or customer sharing, resale price maintenance, what have you, so basically per se categories of violation, although it's debatable as to whether resale price maintenance should be seen as per se or not, still in Turkey at least. The main matter at hand would be that if you can take the position that you can render the entire discussion of illegality moot, and you can provide a commitment to the authority that is going to save its resources from being spent on further investigation into this subject matter, then the Turkish Competition Authority may, with the decision of the board, accept the commitment and take the relevant entity outside the scope of the investigation with a board decision. Next slide, please. The commitment mechanism has been used already. As you can see, these are all 2020 and 21 decisions. In Aslan Nakliyat, the Turkish Competition Board concluded that commitments could only be submitted until the investigation phase is completed. So there has been a negative outcome because the statutory deadline was missed. In the bonded temporary storage and warehouse service providers case, the Competition Board resolved that the commitments submitted by the three investigated undertakings are sufficient and proportionate, and the investigation ended, therefore. So this was a successful use of the commitment mechanism. Also, it was the very first successful use of the commitment mechanism. And in TSP OSEM, the Turkish Competition Board announced that the structural and behavioral commitments are sufficient within the scope of the investigation conducted against TSP and OSEM. So this was yet another successful use of the commitment mechanism. Since then, there have been instances where some entities approached the Turkish Competition Authority for a recognition of commitment. Some of them have been supported by the case handlers of the Turkish Competition Authority as well, but ultimately you have received no green light from the Turkish Competition Board as to the applicability of the commitment mechanism to end the investigation. In other words, the investigation has continued. Next slide, please. And then lastly, you have a recently introduced settlement mechanism in the relevant legislation. You could approach the authority before the investigation report is served on you. So after you have done your first written defense, but before the investigation report is served on you, and you can request a settlement. Roughly said, this would be done by a declaration of intention to settle, followed by a petition that is going to contain an element of what the wrongdoing has been, and the board then would give an idea to the relevant entity as to what the administrative monetary would be if they were to proceed with this current set of evidences, and the board would also inform the relevant entity as to what percentage of administrative monetary fine reduction they have in mind, because they have discretionary powers up to 25%, which in turn means that the entity has a benefit in knowing what exactly percentage of reduction they will be getting. Once the board speaks that kind of a language with the entity will be allowed to withdraw from the settlement application without any prejudice, and by entirely lifting all of the paper trail from the records, or the entity can proceed. This is, of course, under the current draft of the secondary legislation governing the settlement mechanism. The settlement mechanism is in the law in Turkey, but the settlement mechanism is not currently governed with a secondary legislation just yet. So this information that we're sharing with you is basically revolving around the current draft of the secondary legislation as if it has passed as such. Next slide, please. So we are at the end of our presentation, and we had promised a 1-hour presentation. I think we have hit the particular notes and points that we tried to cover with this session, and we wouldn't want to take too much of your time. But in this session, to make sure that we have covered all the bases, let me also take a look at the questions. I see that Daria is asking the commitment mechanism, what is it? Basically, what the commitment mechanism does is that you commit a certain behavior or a structural change or a particular clause in your agreements or anything that is detectable and anything that is enforceable by the Turkish Competition Authority. So anything that goes beyond saying, I'm not going to violate the law anymore. Anything that has to do with your future market conduct or your legal conduct going into the future, or your contractual conduct. And that commitment, if recognized by the competition authority as sufficient to end the violation and sufficient to secure that that violation is not going to happen in the future. And if the authority is of the view that this was a very complex type of a violation to begin with anyway, so an administrative monetary fine may not be that necessary in this particular instance. What was necessary was to give the homework in a healthy fashion to the relevant entity, and it seems they have come forward and they want to undertake the homework too. Then the authority may stop the investigation and may do away with any administrative monetary fine, and then the commitment would be expected and then once the commitment is received and accepted, the authority would write its reasoned decision around the fact that this commitment is now obtained from the relevant entity. One thing that is very critical, and it seems it's going to create some headache also in Turkey, and it has been creating some headache in some emerging markets as well, is that you might be investigating just one entity in a given industry, and all others may be engaging in that kind of a practice as well. And when this entity gives you a commitment and you accept this commitment, does this become the homework of the other entities as well? Could at a later date you investigate those entities, see that they haven't been doing that kind of a contractual change, or they haven't taken on any duties despite the published reasoned decision? Is this in and of itself a knowing violation of what the law of the land is, or should we see the relevant commitment as only impacting the positive duties of the relevant entity, which then in turn will bring another question, which is that aren't you imbalancing the competitors vis-a-vis each other? You're placing one entity under onerous burdens and the others are free to walk as they have been walking. So isn't there another type of discrimination problem here? These are important questions that would need to be discussed in the future as well. And as far as new jurisdictions that are newly bringing in settlement mechanisms and commitment mechanisms, we will have to see what this leads to. Thank you for your patience. I have always tried to be very punctual with timings, and we have had our exact 1 hour. I hope this was useful to the participants.